okay, in a Dropbox as well. But on the same day, from 2 p.m., we will start with group presentation of the same topic. So it will be easier. You don't have to do two work at least. But because for the presentation, I will assess on your presentation skill. And for the assignment, okay, I will look at how you present your works in writing lah. Okay. So for the group presentation, okay, please switch on your camera and mic because I will need to assess you. So I can't assess if I cannot see you and hear you, right? So if you, for example, I think there's one student that have mic problem. Maybe for that, only that 23rd of June, can you please try maybe using your friend's phone or laptop just for that day so that I can assess you, okay? Is there any problem?
Doctor,
Yes. Yes, is it Faris?
is it possible?
Hmm?
Is it possible that we are not using WebEx for the assignment?
For the presentation and assignment, you mean?
Yeah,
Because it's quite heavy?
because WebEx is quite heavy and quite lagging.
Okay.
And
Are you guys
it's a lot of
used
problem.
are you guys used to Zoom?
Very quite heavy and quite lagging.
Sorry, Faris, it's not clear.
Yes.
Yes, okay. I think
Yeah.
you're lagging. I cannot really hear you. So sorry, Faris. Okay. Yeah, if WebEx cause a lot of problem to most of you, I've also access to Zoom. We can use Zoom for the presentation if that's
And
easier.
it's a lot of problem.
Yeah.
Yes.
Sorry, Faris. It's really breaking.
Yeah.
Maybe you can you can log out and come in back. So other than Faris, other students, do you prefer Zoom rather than WebEx for the presentation?
We prefer Zoom, Doctor.
Okay, all right. So for the presentation, okay, okay, I will give a Zoom link, and we will record as well. For that session, okay. So no worries. We will use Zoom, and I'll take attendance as usual. Because with WebEx, it will capture your attendance automatically. But with Zoom, you will need to inform me lah if I didn't take your attendance because I could not check it afterwards. All right, because it doesn't have your login details. Okay. And my only advice for you is only for the 23rd. Please try to go somewhere with better internet connection. Okay, and so that you are prepared because if not, I cannot assess you lah. Alright. So next, okay. Any question as of okay apart from the test that I will explain after this for this individual assignment and the group presentation assignment. Any question? So the dates are okay ya, not apa bersimbung dengan mana-mana ada exam, tak ada kan? Tak ada. Alright, good. Next one, okay, for the test next week, okay, like I've just mentioned, we're going to do it during the class, okay, from 2:15 sharp. So make sure you arrive early next week. So after we take attendance quickly, then we can start the test already. Okay, 2:15 to 3:15. It's going to be an essay question. Okay, you have 1 hour to answer it, and then 15 minutes to submit it via email or Dropbox. Okay, I will either give you the Dropbox link, or you can email it to me. But it needs to be sent to me before 3:30 p.m. Okay, is that clear? So for the selection of topics, okay, it is from the week 1 until week 7 that we're going to cover today. So 1 or 2 or 3 of the topics here will be there. Not all, but 2 for your preparation. Okay, you can read or prepare all those topics up until today. And I think you still don't have access to Clip because Clip is still having some problems to assess it for the students. So for the preparation of the test, after this class, I will send the slides again from week 1 to week 7 via WhatsApp. If that's okay. So are you able to receive it by WhatsApp? Boleh kan? Ke berat sangat?
Boleh, Doktor.
Boleh, Doktor.
Okay,
Boleh, Doktor.
thank you. Alright, that's all. Any question regarding the test next week? So everyone can make it? Yes? It is 10%. Kacang dia kan?
Doktor,
Yes, Ajwat?
untuk format essay macam mana?
Alright. So the format of the essay or the question, don't worry, there won't be a problematic question. Tak ada kena problem solving ke, tak ada. But it's like the tutorial questions that we always do. Explain something, discuss something, compare A and B. What are the differences between A and B? Things like that. So it's very simple. It's just 1 hour, just 10 marks. Alright.
Okay.
So it should be around perhaps 1.5 to 3 pages Word document, if that makes sense. So you can start with introduction and then answer the question and then with the conclusion, like any other essay. Okay?
Okay, doktor.
Alright.
Thank you.
Welcome. Any other question from the rest?
No,
Tak ada, eh?
Doktor.
Okay, so we can proceed. Okay, good. Check. Alright. So for the catch-up and replacement classes, I know we have agreed on the date of Friday 20th and 22nd, but I received messages from some of you that you couldn't make it due to the co-curriculum commitments on the 20th. And also maybe you want to prepare for the exam on this weekend. So can we change it to Friday 27th and Friday 2nd of June? Are you guys happy to do this?
Sorry, doktor. I could not attend for that day.
Which one, yeah, Ajwat?
Sebab weekend memang saya ada training, doktor.
Okay. So any of the dates you can attend lah, Ajwat.
Ya, doktor. Doktor tak boleh buat kalau malam ke, doktor?
Saya okay je, tapi kesian students lain lah.
Okay.
Kami suka malam.
Doktor.
Arif pun suka malam.
Kalau boleh buat malam cuti macam Khamis malam tu, doktor. Esoknya kan cuti.
Boleh. Khamis malam memang saya biasa ada replacement classes dengan student master saya. Alright, kalau macam tu kita buat Thursday night from next week lah. This week dah ada replacement, malam ni dah ada replacement dengan kelas lain. So
Okay,
kita
doktor.
start next week. So Friday, okay, let me change it here.
Atau Rabu pagi.
But Rabu, sorry, saya ada classes Rabu pagi.
Okay, sorry, doktor.
So Monday to Wednesday memang busy. Kalau Ahad boleh. If Ahad pagi atau petang saya okay.
Alright, doktor.
Tapi I think Faris mentioned that you guys have classes already on Sundays, right?
Ya, doktor.
Okay.
So, I guess
So
at
okay. So okay, let's see what others think. Other than Ajwat, are you guys happy to do it on Tuesday night instead of Friday morning?
Yes, Doktor.
Doktor boleh.
Okay je, Doktor. Yes, Doktor.
Bagus, semua bersemangat. Alhamdulillah. Okay, so Thursday 26. So basically I'll be meeting you Thursday petang dan malam lah. Is that okay? Ke boleh lah. Thursday 1st. PM okay? Nanti lambat sangat pula. Boleh?
Boleh, Doktor.
Alright. InsyaAllah, I don't think we are going to end at 11 PM, but I just put here in case we have questions to answer or anything, right? Okay, so these dates are okay for everyone? As of now? So if anyone have any problem, let me know, yeah? Thank you. Let's proceed. Okay, so again, today we're going to discuss the sources of law. Okay, number 2, the customary laws. Okay, so today we have 4 agendas to cover, quite a lot actually. Characteristic of valid custom. Okay, recent position on customs, customs in West Malaysia, and customs in East Malaysia. Alright. So before we start, anyone have any idea what is customary law?
Law yang boleh diubah-ubah ke doktor?
Bukan.
Bukan
Cuba lagi,
custom.
Ajwat.
Macam tu doktor.
Bukan. Again, Howard, undang-undang? Okay, betul. Alright. So, like Hava said, customary law ni undang-undang yang macam customary lah, custom. Yang kena-kena dengan satu society je. Bukan undang-undang yang biasa kita belajar yang berkenaan law kan. Ini undang-undang yang hanya binding kepada certain society, certain type of community je. Right? So, basically, what are the definitions of the customary law? So, customary law is a well-established pattern of behaviors or conduct that can be objectively verified within a particular society. So, it involves a particular society only. For example, like Howard said, adat Pepatih, adat Temenggung, that one are for the Malays. The Chinese also have their own customary law. The Indians also have their own customary law. The native, the Aborigines people orang asli also have their own customary law. Okay, so kita bercakap berkenaan the sources of law, sumber-sumber undang-undang di Malaysia. So sources of law, last week we talk about the English law. Because Malaysia kan has a plural legal system, remember? So customary law are part of the Malaysian legal system as well. Faris tak nampak slide. Anyone else nampak tak slide? Can you see my slides?
Yes, doctor.
Yes, doktor.
Alright, Faris, I think you have a problem with your internet. No problem. Maybe you can just listen first and I'll share the slides after the session, yeah? Okay. Customary law consists of customs, traditions, or usage of certain group of people which in the course of time acquired the character or feature as well as in terms of its enforcement and obligation similar to any established law. In Malaysia, the term custom is used interchangeably with adat or native law and custom. So sometimes we refer to custom, sometimes kita guna adat. So it's the same thing, custom, adat, native law. Okay? So in Malay, it's adat. Okay, Lakshman Marsingha, okay, legal scholar, okay, define customary law as a regular pattern of social behavior which has been accepted by the bulk of given society as binding upon its members because such behavior has been found to be beneficial not only as means of encouraging interpersonal relations among them, but also as being beneficial for maintaining a cohesive society for their individual and collective betterment. That is the definition of custom according to Lakshman. Okay, this definition only refer to custom which are accepted as binding and which the courts will enforce. So we have one custom with adat, semua tu lah. And now we have customary law. Customary law ni custom that have legal consequences, i.e. the breach of such custom will invoke legal sanction, not just moral and social. So kalau adat biasa, custom yang biasa, if there's any breach of it, okay, macam kena pulau ke, kena ada moral ataupun social impact je lah on that person. But customary law, custom yang ada legal consequences. Okay, now everyone clear about custom and customary law? Okay, good. So first, what are the characteristics of a valid custom? So John Wayne Sirau offers 5 criteria for validity of custom in Sarawak. Reasonableness, generality, antiquity, consistency with morality, and not contrary to public policy. These are the criteria for a valid custom in Sarawak. So what are the main requirements for valid customs? So custom must be proved to exist and have been observed by community. Okay, and custom must be proved to have been observed for a long time, and observance must have been continuous and persistent. These are the requirement. Number one, dia kena ada dulu lah exist, and then must be observed by that community. Number two, it must be observed for a period of time, i.e. for a long time. And then that observance must be continuous and consistent. Tak boleh lah pakai kejap tak pakai. Tak boleh. Dia kena continuous. And custom must be legal, obligatory, reasonable, and certain. These are the requirements of valid custom. In Sarip and Mitchell, a case law, Sir Benson Maxwell mentioned that in the case of customs, long usage establishes custom, and it is the custom becomes law, which gives title to a class of persons in a locality and give it to them at once. Okay, so for customs, long usage establish the customs, and that customs, if satisfy certain requirements, will become law. All right. So in terms of the test for validity of custom, we have several tests. So the courts in Malaysia mostly resorted to the test of reasonableness of custom. Reasonable custom actually comes from an English law test to determine whether a custom is accepted. So in Sarah and Michelle, okay, it is regarding the Malay system of customary land tenure, which provided for the payment of 1/10 of a total produce, was expressly approved as being good and a reasonable custom. So this custom, okay, was upheld in Melaka. So it becomes a binding custom. So it becomes a customary law. Okay. And number two, test of antiquity and immemorial. So in the case of Nur Anak Yawai and Borneo Papa plantations in 2001, the court held that the custom would be upheld if a great antiquity and immemorial where there is proof of existence of custom as far back as living witness can remember, in absence of any sufficient rebutting evidence. So test of very antique lah, lama. Maknanya the living witness, maknanya the maybe the oldest people in that community can remember. And number three, test of natural justice. In the case of Mong binti Haji Abdullah, it was regarding a breach of promise to marry between the Muslims. However, in that case, the court held that the strict provisions of Muslim law is not applicable in this case because it would result into oppression. Okay. So Hickling mentioned that it is another system of law. So custom is another system of law in effect, which determines characteristic of custom for the purpose of general recognition and then seeks to absorb that custom into the law in a manner that is harmonious and acceptable. Custom also is unwritten law. Why? Because custom is never enacted by any legislative body nor promulgated. For instance, the oldest law in Rome was founded on basis of understanding and consent of people. So it is the same with the French law, i.e. before the codification of the Napoleonic law. Okay, and English common law itself at one time consisted of the collections of unwritten custom. So basically, some writers regarded custom as unwritten law. Okay. Some say that custom is also merely a positive moral rule. John Austin said that custom is merely a positive moral rule because it is neither the creature of a state nor a judicial decision. It can be transformed into a positive law when adopted by court. Okay. And custom becomes law after it receives judicial recognition. Thus, custom becomes law after it receives judicial recognition. Before receiving judicial recognition and becoming clothed with legal sanction, custom is merely a rule of positive morality observed by citizen. And in most legal systems in the world, custom is a source of law subordinate to a statute. So it is a part of the sources of law in those countries, including Malaysia. So customs are proved by repeated acts practiced over a long time, leading to conclusion that by common consent, the customs have become the law of the place. So in Sarib and Michel, it was held that in the case of customs, long usage, i.e. kelaziman in Malay, establishes custom, and it is the custom becomes law which gives title to a class of persons in a locality. So this is regarding the long usage. And besides, custom may be proved by public record or opinion of persons likely to know the existence of such traditions and village oral traditions. In the case of Sagong bin Tasi, it is regarding the oral history of orang asli relating to their practices, customs and traditions, and their relationship to the land should be admitted as evidence subject to Evidence Act. But the oral history must be of general public interest and the statement must be made by the competent person. This is how to prove such custom. Yeah. How about adat? Since adat in Malaysia is mostly unwritten, proof may be difficult, especially in West Malaysia, because there is no native court system and no codification of custom. So custom are unwritten lah in Malaysia. Therefore, ordinary civil court have to decide on the existence, proof and validity of such custom. Proof of custom in English law may be used as guidance in general application of custom, i.e. the test of reasonableness, morality and public policy. Okay, so memang custom is source of law, but in order to use it in court or to enforce it, okay, the court must decide on the existence, proof and validity of such custom. That's why we are learning those rules just now. Does that make sense to you? Yes?
Yes, Doctor.
Good.
Yes.
Good. All right. Number two, now we're going to cover the position of custom according to federal constitutions. So custom is a system that arranges laws on social attitudes, politics and constitutional form. Okay? As mentioned before this, custom is one of the unwritten law or historical sources of law. The federal constitution recognizes the position of custom as one of the Malaysian legal sources whereby, in certain situations, customary principles are acceptable by court as the basis for decision. Article 160, Section 2 of the Federal Constitution mentioned that law includes blah 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 and any custom or usage having the force of law in the federation or any part thereof. So it mentioned that any custom or usage having the force of law in the federation is included into the definition of law according to our own federal constitution. So that's why custom that have the legal force of law, okay, are sources of Malaysian legal system. So Dr. Abdul Aziz Bari mentioned that in the context of Malay custom, there are many practices and ceremonies which are practiced in daily life. For instance, adat, contohnya berkahwin, we have adat berminang and then adat bertunang and then adat bersanding, but they don't have the force of law. So they are just adat but not having the force of law. So they are not law in accordance with the Article 160 of Federal Constitution. But there are certain customary principles such as harta sepencarian, okay, which said to be originated from the adat berpatih system, which is accepted and applied by courts in determining property dispute between husband and wife upon divorce. Because harta sepencarian does not exist in Islamic law. It is actually existed from old adat berpatih system. This is the same with the principle of jual janji in purchasing and selling lands among Malays. So there are certain adat or custom, Malay custom that now has force of law and becomes law in our system. So the position of custom in Malaysian legal system has to be understood in the context of legal sources recognized by courts. In the Malaysian legal system, okay, we have 7 legal sources. Among these are, we have federal and state constitution, okay, we have statute or legislation, i.e. the acts passed by parliament, and then we have also subsidiary legislation, undang-undang kecil, okay, i.e. legislation made either by the ministers or bodies given legislative power under certain statute. And then we have decision from the courts, case law. And then we have custom that we are learning today. We also have English common law and rules of equity and Islamic law. These are the 7 legal sources in MLS, Malaysian legal system. So now we are learning one of it. Okay. What is the position of Malay custom? Although the position of custom as one of the legal sources is not a vital and very important in comparison to other sources, but the existence of custom within the preparation of Federal Constitution has indirectly raised its status. Because Article 116 Section 2 mentioned that under the definition of the word Malay, it mentioned that the Malay custom is regarded as one of the criteria in determining whether a person is a Malay. Okay, and a position of Malay custom is further emphasized by the relationship with the rulers. In the 8th schedule of Federal Constitution, it mentioned that a ruler may act in his discretion in performing of several matters, including any function as the head of religion of Islam or relating to the customs of the Malay. So again, the word custom is mentioned in the Federal Constitution. And the appointment of persons to Malay customary ranks, titles, honours and dignities. All these provisions, okay, reflect situations whereby ruler is allowed to act on his own, independent from government's advice. It is a form of acknowledgement by Federal Constitution towards a close relationship between the ruler and the Malay custom. Due to the ruler's important symbol of Malaysian identity, the Malay custom often is listed in Federal Constitution. The word custom is mentioned in the Federal Constitution. Okay, the next part, which is also I think the big part of today's lecture. So now we're going to learn about the customary laws in Malaysia. So we are going to learn this information in 4 parts. Okay, the first one is the Malay customary law, and then we are going to learn the Hindu customary law, and Chinese customary law, and then the customs of the indigenous people. So basically, we are a nation with multi-religious, very diverse nation. So we have several customary laws, okay, applicable to our legal system. The first one, we have Malay customary law. It is also known as adat, which is the right to conduct and in common with it stands for a variety of things connected with the course of social media and culture. Adat refers to the rules of etiquette, the code of conduct and ceremonies prescribed for a particular occasion such as marriage. So, Malay customary law includes customs which have been recognized as law and have legal consequences. Muhammad and Ali adalah scholar talk about the nature of adat institution whose law and nature regulated social, political, and national day. It is not merely habit used as a tradition of Malay people. Okay, however, nowadays adat is no longer regarded as purely customary, but has become part of the Malaysian system through, though even if it varies from one state to another. So in the Malay customary law, we have adat menggong and adat berpatih. The first one, the adat menggong. Adat menggong is also known as adat Daud. So the adat menggong is influenced by Islam. It is also influenced by Hindu law, especially in criminal law. Adat menggong involves the elements of tradition and punishment. So the adat law digest is the digest, okay? Providing adat menggong which includes pahang dadas, kedah dadas, dan tenang perak, selanggang dadas, okay? Temenggung, on basis territorial limits, the structure of administration is on basis territorial limits, constitutional and security, classified in the group consisting of the Sultan, Bendahara, Temenggung, Chabanda. So it is the system relates to the Majapahit legal system. Okay. And Adat Temenggung is a patriarchal system. It deals with both public and private law. However, in the modern world, only a few Adat Temenggung is prevailed due to the introduction of the Charter of Justice, which apply English law to our system. Therefore, only certain aspects of Adat Temenggung, such as family law, inheritance, and property, such as perceraian, are recognized by the court. So currently, only certain aspects of Adat Temenggung are still exist as a customary law in Malaysia. For instance, in inheritance and family law, Adat Temenggung is based on Islamic law and now administered by the state authority under the List 2 of the 9th Schedule of Federal Constitution and Administration of Islamic Law Enactments of States. Because the Islamic law are masters of the state, so it governs by each state and not by the federal. So what is harta sepercarian? Harta sepercarian are property that are jointly owned by both spouses during the marriage. So it is recognized in almost all states. I think you have may have heard about harta sepercarian before. Okay. Any question until now? Everyone's so quiet. Any question? Oh, okay.
Doktor.
Yes. Alright.
Nak tengok
Cik
yang
nak tanya soalan ke?
previous slide.
This one?
Lagi tu. Yang selama Kedah Digest tu.
Okay.
Apa maksud dia? Tak berapa clear.
Alright. So basically, previously, Adat Temenggung ni dah it's already been codified. So before So in Pahang, Kedah, Perak and Selangor, they have law, codified law that are based on Adat Temenggung.
Jadi dia guna lagi tak? Tak guna dah.
Itulah yang berguna sekarang only certain types like family law, inheritance and property. Harta pencarian, yang those law ni dah jadi part of Islamic law of states. Dan harta pencarian tu. Ni historical lah in these ones. Okay? Is that clear? Alright. Any other question? No? Alright. For instance, in Perak, under the Perak State Council Minute 1907, okay, on divorce, 1/3 of the harta pencarian is given to wife and 2/3 of it will be given to the husband. That is the rule in accordance with the Perak State Council Minute 1907. Ni back then lah. Okay, but this rule did not apply in these cases and had been misunderstood. For example, in the case of Teh Rasim and Niman, okay, the divorced wife could claim half the value of land which she helped to cultivate. So it does not in accordance to the minute. And the case of Wan Mahatan and Haji Abdul Samad, harta pencarian was misunderstood as harta syarikah. This is another concept under Islamic law. Therefore, the wife entitled to half of the share, even though she had not worked on the land. So different for Adat Temenggung, so different states their own legalizers lah. Legal code on like specific law relating to harta pencarian. In Selangor, the position of harta pencarian is also uncertain. In the case of Rama and Latun, it is also misunderstood harta pencarian as harta syarikah under Islamic law, and thus the wife claimed half share. In the case of Haji Rama and Afar, the widow entitled to 1/4 of value of land which she helped to cultivate. So different rule even here. Also in Kedah, the position was uncertain. In the case of Wan Nab and Jasin, it is impossible to determine amount of harta pencarian involving cash and not land, and therefore the wife entitled to 1/3 of the share following other states practices. In Terengganu, the Terengganu Memorandum mentioned a procedure to prove harta sepencarian by taking oath in mosque and administered by mosque official. And in Pahang, there is no fixed rules as to that. The wife could claim her shares either used under Islamic law or adat. Committee of the Chief Qadi and Qadis viewed the wife entitled to claim harta sepencarian on divorce or the death of husband. So basically, the rule on harta sepencarian in those states, there are no fixed rules lah. In the case of Haji Saimah and Haji Sulaiman, a widow claimed harta sepencarian. Okay, but the opinion of committee regarding harta sepencarian was ignored. Therefore, it was held that harta sepencarian as an adat did not exist in Pahang, and therefore it applied Islamic law to that case. So basically, it depends on the judge, okay, on whether it would apply the harta sepencarian as an adat. Okay, in the case of Reed Alang and Niat, it held three main points. If a wife would on land, she is entitled to half of the share, and if not, only 1/3 of the share. However, harta syarikat created confusion in this case, and the basis of claim was local adat, and harta syarikat was used to show purely Malay idea. So basically, harta sepencarian and harta syarikat are different, but the court kept using it interchangeably. In all states of West Malaysia except Johor, the Chief Qadi and Court of Qadi have jurisdiction to hear claims for harta sepencarian, but it is not exclusive. The claim may be made in civil court also. In the case of Robert and Umi Kasum, it was held that harta sepencarian is a matter of Malay adat. Once established, it will be judicially noticed. The property acquired during marriage raises presumption that it is harta sepencarian, but this is rebuttable. And divorced Muslim husband may claim a half share as harta sepencarian on immovable property jointly acquired during marriage. The fact that such property is registered under the name of the wife is no bar, as the indivisibility provided under the land code does not affect harta sepencarian. So this case, okay, mention three principles on harta sepencarian, and it's very important. So everyone is okay as of harta sepencarian dan adat temenggung. So basically, in adat temenggung, the exist law that are still, applicable is harta sepencarian, but it depends, and very different from one state to another. And most of it already come not under adat, not under law, but now under Islamic law as well. So it depends lah on certain state. Alright. That's how about adat pepatih? So the written adat pepatih, okay, we can look at the digest from Sungai Ujong and the Minangkabau digest from Perak and the digest from Kuala Pilah. So adat pepatih is different. If the adat Temenggung is about patriarchal system, adat Temenggung, adat pepatih is all apalah, I can't remember the term, but it's on the opposite to the patriarchal system. So the adat pepatih covers matrimonial law, property, criminal law and punishment, administrative law and adoption. Okay, so for adat pepatih, okay, these are the administration of it. Okay, it will be diketuai oleh Yang di-Pertuan Besar, followed by undang, lembaga, bapa and mamak. So not all lembaga can be elected as undang because only lembaga from 4 luwak are qualified. Method of election of undang will rise from one luwak to another. So election of Yang di-Pertuan Besar must receive unanimous vote from the 4 undang and he must be a delegate from Minangkabau. These are among the rules of adat pepatih. In the case of Datuk Menteri Osman Baginda and Datuk Wan Bisai Alwi, the issue over there was whether the election of 15 Undang of Jelebu was valid. Okay, the federal court refused to decide on the matter because the issue was under the power of Dewan Keadilan as the highest adat constitutional body by the virtue of Article of 9 Negeri 9 Constitution. So these are the example of written and binding adat pepatih in Negeri Sembilan. And in the case of Datuk Haji Shahri, the court re-emphasised that any matter relating to Malay custom in Negeri Sembilan falls within the jurisdiction of Dewan Keadilan. Therefore, the civil court has no jurisdiction by virtue of express provision of Negeri Sembilan Constitution. So the position of Negeri Sembilan Adat Society is recognized under Article 71, Section 1 and 2 of the Federal Constitution. Okay, and in the Negeri Sembilan Constitution itself, in the Small Estate Distribution Ordinance and the Customary Tenure Enactment 1960. Alright. So in adat pepatih, okay, there are three types of property: ancestral property, personally acquired property, and jointly acquired property. So the ancestral property belongs to the tribe, and it vested in the female member of tribe as the trustee. So kalau adat adat Temenggong is like Islamic law, okay, which confers trust or confers the ownership of the land into male. But for adat pepatih, okay, it mostly for the females, okay, and it cannot be disposed by will. So once the property is acquired and once it's inherited, it becomes an ancestral property. In the case of Sapian and Tiamat, where land is ancestral property, its owner must be a female member of the clan. Okay, it must be inherited by a female member of the clan. And in the case of Haji Hussein and Maheran, the newly acquired land may be converted into ancestral land if the owner informs lembaga that he wishes to convert it. It may also become the ancestral once it evolves into female heir upon the death of the owner. And number two, they have personally acquired property, which are harta dapatan and harta pembawa. Harta dapatan is wife property acquired before the marriage. So the harta dapatan will remain with the wife upon her divorce, and it will go to the customary heir on her death. For example, any gold ornaments or property given by her parents before her marriage. Harta pembawa is the husband's property acquired before marriage, and it will also remain with him if he divorced, and it will go to customary heirs on his death. Both harta dapatan and pembawa must be declared before the elders at the time of marriage. If either of the property increase in value during marriage, the increased portion is treated as jointly acquired property. A gift to a married man by his family is treated as harta pembawa, and he cannot dispose of it without consent of his family. It is the same position for the married woman. Number 3, we also have the jointly acquired property. It is known also as harta sepencarian. These are the properties acquired by both husband and wife during that marriage. So on divorce, property will be equally divided, except if there's a conditional divorce where the wife make a condition that he will retain the whole property, or in the landed property, the wife retains whole property, for example, rice field and farmland acquired from jointly earning. These are the rule of adat pepatih. On the death of the wife, the land goes to the female issue. On the death of the husband, okay, the harta sepercarian goes to the wife, and on the death of the wife, the harta sepercarian goes to the husband, provided that there is no issue from the marriage. These are the sayings of the 3 adat properties. Wife property remains, the husband bringings go back to him. Joint earnings during marriage are divided. On death of husband, they go to the wife. On the death of the wife, they go to the husband. About the land tenure of ancestral land according to adat pepatih, The inheritance of ancestral land is matrilineal. This is the word, sorry, matrilineal. So the female is vested with customary property, for example, kampung land, sawah, and customary house. The female must be identified with a piece of land. So every female must have a piece of land. The lembaga will make sure the female members of the tribe is not deprived of the land. So under Torrens system of registration, the holder of registered title has legal title. Therefore, the owner of ancestral land must endorse the word customary law on the title of the ancestral land. Dalam geran tu lah. Why it must be endorsed? Because A, to restrict transferability of ancestral land. Number 2, to secure right of member of the clan to the land. And number 3, as a mean through which adat rules can apply, and to prevent other law than adat pepatih from being applied to that piece of land. But if ancestral land is not endorsed, the collector of land may enter endorsement. How about the land tenure of other land? Other lands, other than the ancestral land, are endorsed as customary land under customary tenure enactment. Okay, the Federated Malay States and National Land Code in Penang and Malacca. The transferability of land is limited, i.e. the land can only be transferred, charged, or leased to a Muslim Malay habitually speaks Malay language, conforms to Malay custom, and born before Merdeka Day in Federation or an issue of such person. So these are some of the conditions endorsed, okay, for the customary land. In the case of Tan Eng Lock and the state of Tam Kim Tiong, the issue was whether the Malacca customary land was transmissible by will to defendant who is not a Malay, not a certificated person, and not natural child of the deceased. It was held that the certificated person, as proprietor of customary land, has permanent and heritable right of ownership and may transmit land according to any succession. In this case, as the will is the most important, therefore defendant was entitled to customary land even though she was not Malay or legitimate daughter of the deceased. So in Malacca, okay, the will prevails. The non-endorsed land title. The title to land which is not endorsed with the word customary law is also recognized by adat pepatih as matrimonial property. As we discussed the marriage properties, we have 3 types: harta pembawa, dapatan, and harta pencarian. So, now what time is it? Okay. Okay, let me stop sharing first. So that are the Malay customary law. The contemporary of it, okay, we will discuss at the end of the session, but that one is mostly historical. So it depends from one state to another. So maybe can we have a 10 minutes break? Everyone looks tired. At least the one that I can see lah, Ajuat and Howell.
Okay, Doctor.
Alright, see you in 10 minutes. equity will be applicable only if does not go against or conflicts with our existing local circumstances of Malaysia, subject to qualification of local circumstances that may render necessary. Up until here faham tak? Okay tak ke? Okay. Alright, thanks Hawa. Okay. Next we go to the effects to Sabah. Alright. So 1 to 5, will be applicable to Sabah and Sarawak as well. Okay. But Sabah and Sarawak have more applicability of English law than Peninsular Malaysia. So 1 to 5 is applicable, but the only differences are, number 1, the cut-off date is different. So if in Peninsula, it is on 7 of April 1956. Okay, in Sabah, the cut-off date is the 1st of December 1951. Okay, and the second difference is, if in Peninsula Malaysia, the court shall apply the common law of England and the rules of equity only, but in Sabah, one more applicability is the statutes of general application. Okay. So if we go back to the law here, the statute in Peninsula Malaysia only apply the common law of England and the rules of equity. But in Sabah and also in Sarawak, apply the common law of England and the rules of equity together with statutes of general application. So more reception of English law are available in Sabah and Sarawak compared to the Peninsula Malaysia. Okay.
Doctor,
Yes.
what is statute of general application? Can you explain?
Alright. Statute of general application is the general statute, that of law, any statutes that have been the written law in England lah. Okay? That have general application. That is not very specific to only English subjects, for example.
Why is it only applicable to Sabah and Sarawak?
Okay. Number 1 answer is because the law says so. The number 2 answer is because Sabah and Sarawak, because of the historical aspects lah. So the CLA 1956 was based on the CLO. We go back here. The CLO 51. Okay, but for Sabah and Sarawak, there are revisions to it, in 1972. So not just in CLA, once you will be learning the law, throughout your study in UNIZA, you will learn that memang Sabah and Sarawak got or received we can say special privileges lah. They have differences than for instance, law applicable to that and here, and also even in federal constitution, they have certain privileges. Okay, that was actually their conditions when they want to join Malaysia back then lah. Okay. Alright. So when learning the law, you will notice that we have different sections and different provisions and different applicability to the Peninsula Malaysia and Sabah and Sarawak, because the statutes that were coming from were different, and then when they revised the CLA in 1956, they only included the provision for Sabah and Sarawak. Okay. Alright. And the other differences for Sabah is the proceeding by way of habeas corpus, or for an order of mandamus, order of prohibition, order of injunction. Okay, these orders, the specific orders that will be available in Sabah, which be the same way that they are available in England. So for these certain orders, the reception of English law in England will be applicable the same way in Sabah. In Sabah je lah. Okay. How about Sarawak? Okay. The Sarawak, again, the differences is the cut-off dates, okay? For Sarawak, is even more earlier, 12th of December 1949, okay? And besides the common law and rules of equity, the statutes of general application are also applicable, okay? And then there is a special provision regarding the Acts of Parliament of UK that is applicable to Sarawak under Section 3 and 4 of the Application of Laws Ordinance of Sarawak. As you can see here, okay, the general applicability of the common law or the English law that are applicable in Peninsula Malaysia, Sabah and Sarawak are different. Okay, up until now, everyone is clear?
Yes, Doctor.
Yes, Doctor.
Okay, very nice, good. Right. So next, then, are English statutes of general application applicable to West Malaysia? Okay. Now, if we refer to the section 3 of CLA, we can say that it's not applicable, right? But what the scholar says. So the scholar says, okay, the Prof. Bartholomew says that English statutes are applicable. Okay, but then Joseph Chia said it is not applicable. Why? So even if you refer to the law cases in Malaysia, it says that the English statutes of general application is not applicable to West Malaysia. Okay. And to support that, okay, we have three cases that we can discuss here. For example, okay, in the case of Mohtar and Arumugam, the Court of Appeal held that the remedy, which was the damages in the nature of interest for delay of payment, okay, was a creature of English statute and not applicable in Malaysia. So in this case, okay, the remedy that was applied, okay, by the party, okay, was a creature of English statute or available in the English statute. Therefore, the Court of Appeal judge said that, okay, the remedy was not applicable in Malaysia. That's in the case of Modalan Plantation, Sendang Berhad and Rachuta Sendang Berhad. Okay, it was held that the defense of legal set-off, which was based on an English statute, okay, is not applicable in West Malaysia. So again, similarly, the court said that, okay, because the defense was based on an English statute, okay, so it was not applicable to us. And next, okay, is a recent case of Pushpa, anak lelaki MMS Raju and Malaysian Cooperative Insurance. Okay, in this case, okay, the plaintiff sought to invoke an English statutory provision to revoke nomination by her deceased husband in his life insurance policy made before their marriage. The judge dismissed her application. Judge said that Section 3, Subsection 1, Subsection A of CLA allows West Malaysia the application of common law of England and the rules of city and not statutes of general application. So if you have questions about whether the English statute of general application is applicable in West Malaysia, the answer would be no. Why? Because Section 3, Subsection 1, Subsection A of CLA 1956 says so, and also because of these cases that have been decided by our courts, okay, says that, okay, the statutes of general application will not be applicable to West Malaysia. And of course, it is applicable in Sabah and Sarawak. These are the main differences between the reception of English law in Peninsula Malaysia and Sabah and Sarawak. Alright. Up until now, everyone is clear? Everybody is clear?
Yes, Doctor.
Okay. Alright, so I think can have 10 minutes break and then we will continue with the rules of equity and section 5. Alright? See you soon.